And so what I'd like to do is to start by introducing the professors, and then I'd like everyone else to introduce themselves. I'll start alphabetically, B and C. I'll start with Professor Biner. Professor Biner is a professor of law at University of Arkansas, Little Rock Bowen School of Law. She's the immediate past dean of the school. And her claim to fame is when I came to the law school in 2004, she became my mentor. We won't go through the whole story about how, but she became my mentor and guided me through the process of becoming an associate, then a full professor. And I know Professor Crooms can attest to that's no easy task in any school. And so I want to thank her. She is a professor of constitutional law, among other things. And I want to thank her for joining us. The second professor, I think Sam knows well, or knows, I don't know how well. I don't know if you, I'm sure you had to take her at some point, but is Professor Lisa Crooms, who is the immediate past acting dean of the Howard University School of Law. And she's a professor of constitutional law. I've known her for many, many, many years. And she is also on the board of the Center for Constitutional Rights. We're going to talk tonight about, as I said when we first started, we're going to talk about race-specific remedies. The context for it, which I know Professor Kroom and Professor Biner know, but I want to repeat it, is that National Council of Black Lawyers received a grant through the Decolonizing Wealth Project to provide support and assistance to the many reparations task forces and commissions that have been formed all across the United States. I understand now they number in a little bit, around 100, maybe a little bit more. We just developed a formal relationship, I would say, when I say just, I mean like last week, with the organization First Repair, that is kind of the crucible, so to speak, for them. They have regions that they are working with the reparations commissions and task forces. But the grant says the support we would provide would include providing legal analysis or how to develop a constitutional case, whether it be for legislative or for litigation, in addition to other things. But that's the primary purpose of tonight. We also are going to do a little work on buy-in. How can communities get buy-in from people who either aren't on the commission for reparations, or even among the commissioners? Every commissioner may not support reparations or the form of reparations that they are talking about. So tonight we have our experts, and I do say expert. I don't hesitate at all to say that they both are expert in constitutional law. I would rely heavily on their opinions. I've already relied heavily throughout my career on Terry's, Professor Biner's opinions. But we really want to talk about it from, if I dare say, and they know me and you all know me a little bit, but I'm practical. What can we do practically? How do we move forward to advise the community task forces or reparations task forces and commissions on how they can go forward to develop reparative relief? And I've kind of formulated a kind of big question that I sent them. It's one question with about 5 parts. And we'll just open it up. The umbrella question I asked is, we see in fair admissions that the Supreme Court's majority indicates that there are, in quotes, 2 compelling interests that permit resort to race-based government actions. One is remediating specific identified instances of past discrimination. that violated the Constitution or the statute. So that's the basis of these 5 parts. So I'll just start with one, and then if we flow easily into another, we can just do so. But in attempting to get states and local communities to develop and agree to reparative programs, must local communities actually go to court and obtain a decision that the state or locality has violated the Constitution or a statute? So I'll open it up to maybe let's start in reverse alphabetical order. Professor Crooms, and then Professor Biner, and anyone else.
Thanks, Ajwa. I think the short answer is if your chosen amendment is 14, then I think the cases point in the direction of it's got to have been adjudicated. One way that I get there is through some of the understanding that dicta is not binding, right? But some of the dicta from Grutter, as well as, even though higher ed and K through 12 prior to Students for Fair Admissions were 2 separate lines of cases, I've used Student for Fair Admissions as bringing the higher ed cases in line with the K through 12 cases. So now what's permitted in higher ed looks like what is permitted or not permitted in K through 12, based on, I guess, most recently, oh, come on, parents involved. So if you're coming through 14, I think your answer is yes. If you're coming through 13, I don't think so. But I recognize that those are 2 very different constitutional bases for claim, where 13, I think, by its own terms, combined with the power granted to Congress under Section 2, presumes that in dealing with the badges and incidents of slavery, it actually, I can't think of a good way to put it. It stands in a reparative sort of posture, without further proof that there was wrongdoing by an identifiable actor, or specifically a state actor. I think that there is a lot more room with 13, but it's underused and not particularly, for whatever reason, right? 14 became the workhorse. 13 ended up not developing in a way that one might have thought it could have, but I think that there's potential there to use 13 if you're relying on the federal Constitution.
Karen, Professor Biner?
Sure. I think there's a little more room to maneuver under the 14th Amendment. I think there is some support, and of course, this court might not. This court, of course, may be not the greatest court for these kind of arguments, but in the past, the case laws such as Croson, and I know Richie's in the Title VII context, but they're all citing Croson for this strong. You have to have a strong basis and evidence to support a reparative program, which suggests, or a prima facie case, sometimes they talk about, which means you wouldn't actually have to have an adjudication against you. You would just have to have that kind of evidence to suggest that a strong basis in the evidence to suggest that there has been discrimination, or that there is discrimination that you're trying to repair. Now, I say that because, they cite in the Harvard case, they cite the Seattle School District case. But everything sort of ends up going eventually, if you kind of follow the citations, they go back to Croson, which does have that strong basis and evidence language in it. I think part of the reason that they do the parents' case is they may be trying to, instead of citing Croson, try to avoid avoid that language. But nonetheless, nobody's overturned it and it's still there. And they did quote it, in the Ritchie versus DeStefano case. I know that's a Title VII context. They cited Croson in that case, which is a relatively recent one. I don't know if you guys remember that case, but it is, again, I'm going to just reiterate, it's Title VII. In that case, a fire department decided not to invalidate a test because it was having a disparate impact based on race. And the court said you can't do that. That's racially discriminatory unless you have a strong basis of evidence citing Croson for thinking that you were actually discriminating based on what you were doing. You couldn't. But so they still are citing that relatively recently. So I wouldn't give up that. And of course, if you have an adjudication, you're golden. But without an adjudication, I think you could use, develop that evidentiary basis with a city or state that is inclined to want to give some reparations for its continuing discrimination. And I think there's at least a basis. They certainly would have to disavow that position, which they haven't officially done yet. So I think there's a little room to maneuver. And of course, I agree with Professor Crooms. The 13th Amendment is wide open. I think it's been theorized by scholars and it really hasn't been used yet in the court system, but it's got potential as well.
I'm going to move on unless somebody has a question or a comment other than the two professors. Okay. Or Professor Crooms, you have something to say in addition to what you said before we move on?
No, to say that I might be a bit more pessimistic. I don't disagree. I just think that there's a lot of water under the bridge between Croson and now. That at best the odds are 50-50, and that's being optimistic, right? And I think taking into account the current configuration of the court and where the country is in terms of the extent to which we as a nation are prepared to not just remediate, but acknowledge and grapple with histories that may not have landed in court, right? But it seems that, I'm trying to think of the case. Oh, the Berea case, right? It's one of those cases where, okay, liberty generally gives parents the power to decide, among other things, how their children are going to be educated. But that seems to work until parents want their children educated in integrated settings. So Berea knocks that out, and I think you come fully into the contemporary period. That's where we end up with parents involved. That in some ways, what it is that the parents were attempting to do who weren't members of parents involved, right? They were attempting to construct a school district that was based on their own values. And the community identified the values that they were interested in furthering as including getting rid of racially identifiable schools. But to say that, I don't know, the traditional police power that states have is somehow limited when those states decide, or subdivisions of those states decide, that they want to have integrated schools, right? And that they want to use race as one of the ways that they're going to get there. Or the reverse of that is to get rid of racially identifiable schools. That it seems that police power comes to a full stop. And we then resort back to sort of federal power and laws, where I know that this is dangerous, right? Because it does kind of sound like a states' rights kind of analysis. But in some ways, perhaps, I mean, granted, let's take away the pejorative piece of it by calling it states' rights, right? If it's about local control, right? And that if you view the 14th Amendment, for example, as being triggered when local control goes wrong, then I think that the default position gives plenty of room for, let's say, more progressively inclined state and local governments to make choices that align with the values of the people who are parts of those communities. And that at least parents involved seems to say that's illegitimate. It violates the Constitution unless you can say that this school district, by way of adjudication, not just by way of saying this is what we did, we've got proof that you've discriminated in the past, and this measure is intended to remedy that discrimination. I just think we find ourselves in a catch-22 that I'll leave it at that. I think we find ourselves in catch-22.
So I think I would add on to, yeah, I think you're it can lead to a catch-22. I think one thing that they're going to look for, if you take my approach and say, okay, we're gonna develop a strong basis and evidence that there's discrimination going on, whatever it might be, in city contracting, doesn't have to necessarily be schools, whatever it might be. I think it's pretty clear that a court, to uphold some race-based remedial measures, they're going to want to see you tried something race neutral. So I think you have to definitely add that into the mix, based on, they're looking for, okay, did you try anything race neutral before you went? I'd be okay, you see that there's some discrimination in this area. Did you try anything race neutral before you went and decided that a race specific remedy is what you need to do? So just bear in mind, even under my more positive, like, hey, things might work without having the adjudication approach, I think they're going to have to try something that's race neutral first, before they implement, and see how that works before they implement a race-based remedy. So I would add that on to my comments.
Well, let me go on to the next question. I have formulate in my brain something to follow up with what you both are saying, but it's not as clear as I'd like my head to be right now, so I'll come back to that. Must the constitutional statute be the federal constitution or federal statute, or can it be the federal constitution and a state statute? Let's start with Professor Beiner this time.
Well, I think for the most part, I mean, it's probably going to have to be something federal, just because it's going to trump anything statewide. So, if it's a violation of a state law, and you provide a race-based remedy, they're still going to look at it as as unconstitutional under the federal constitution. So as a practical matter, I think it's going to have to be federal. And I do think when they said constitution or federal statute, in the Harvard case, I think one of the things they were thinking about was Title VII, because that is a case, again, the Ritchie case is one of those where they talked about equal protection in the 14th Amendment in the same context as they were talking about Title VII. So I think that's one of the statutory areas that links up with what they're talking about here. Professor Crooms might have others that link up as well that might cause you to be able to make a race-based remedy. I think Title VII is one of them. So she might have others.
Can
but
you
I
tell
think,
us what Title VII is, just in case?
Sure. I'm sorry, guys. So Title VII of the Civil Rights Act of 1964, it prohibits discrimination in employment based on race, among other classifications. And there's case law citing some of the case law there. It also cites the equal protection case law about when you can have a race-based remedy. And right now, actually, affirmative action is recognized as a defense under that statute. I don't think it's going to last. But nonetheless, they have not overturned that you can have affirmative action programs. You can have race-based hiring programs under Title VII, but I would imagine this court would strike one. I think we're not seeing employers implement them, and that's why we haven't seen it raised in the court system. But a violation, if you had, if you could show that there was race discrimination in employment, for example, by a city or a municipality or whatever, police department, I think that's the kind of statutory basis that would also, where a race-based remedy would be appropriate.
Professor Crooms?
I agree. I was sitting here thinking, okay, but it keeps coming back to a loop. So even if, let's say, we could say that there were adequate and independent state grounds for the assertion or the claim, it's still going, those state grounds are still subject to an assessment as to whether they are constitutional or unconstitutional under the federal constitution. So adequate and independent state grounds in this area seems to be kind of more illusory in some ways than anything else. I do wonder, however, all right, so most of this is thinking about equal protection. But I wonder, similar to my thoughts about, let's say, the 13th Amendment and the idea that it's underutilized, I feel the same way about privileges and immunities of citizenship, right? And I think this is taking the originalists at their word, right? So we're going to embrace originalism just for a moment. We're going to embrace it just for the purposes of interpreting the Reconstruction Amendments based on what was going on at the time and what the framers of those amendments intended within the immediate context in which they were ratified. Privileges and immunities of citizenship could provide another avenue, although it narrows the rights, as it were, to those who are citizens rather than more broadly to those who are persons or people. Yeah, I want to be, and I'm hearing you, Audra, in terms of being practical, and I try to be practical. I don't think that I've been a professor so long that I'm no longer practical, but I really have been grappling with this notion of equality, right? Because equality within the context of the United States, and particularly the US Constitution, what tends not to really get sort of put out there is equal is a relative measurement. So it's equal to whom, right? And in the US, within our constitutional sort of structure, equal to the other side of equal is white, right? So is that where we're trying to go? Right? Is this about ensuring that people of African descent in the United States are in fact afforded some kind of remediation, as it were, in the interest of making them equal to whites? And I think it's an interesting question. And I think the answer depends on not necessarily what the framers intended, but what's our ultimate project, right? Is our ultimate project, let's say, freedom and liberation, whatever that entails? And then the second question for me then is, does equality get us farther down the road with respect to either of those objectives? And I'm not necessarily convinced that equality is going to get us there, because what it doesn't do, it doesn't decenter whiteness as the norm around which racial full personhood or citizenship continues to be constructed. It's just the extent to which you can make those who aren't white look white, but for the fact that they just so happen to be Black. It's like you got to set it up that way in order to even be able to establish a credible claim of equality. But that takes us, I don't know that takes us far afield, right? Because it seems to me that reparations is linked to liberation, right? Reparations is linked to freedom. And maybe that means we have to think in a slightly different way about what we're asking for based on where it is we hope to end up. I don't necessarily want to be equal, right? I want to be free, but I don't want to be equal.
How would, well, Professor Biner, and then I have a question. Do you have anything to say in response?
Yeah, I think it's a question in terms of the overall project. I also agree that the Privileges and Immunities Clause also underused and has potential. So, both the 13th Amendment and the Privileges and Immunity Clause, I would be looking at scholarly work in that area to see what people are writing about, because it's not getting used in court. But they both have potential as novel approaches to try to get at some of this. And I am sympathetic to Professor Krooms's notions, ideas about maybe equality is not what we're looking for here. But that's a bigger question for the project overall, in terms of what the goal is. I think you need to get an acknowledgement of harm before you're going to get reparations. So however we're going to do that, whether it's we're going to do fact finding as a city to show that we've done things that we have been basically systematically keeping people out of opportunities, and I think that makes the case, even whether it's in court or with the population. You need to acknowledge, you need to identify and acknowledge the harm, and then I think the reparations sort of flow naturally from that. But what that exactly looks like, whether it has to be a lawsuit or, my positive way of thinking, maybe not. We'll just have to wait and see what, I mean, I think you could fashion it either way. And I do like thinking about theorizing some of these other constitutional provisions as possibilities that the court hasn't really addressed yet.
The purpose of our project is to advise municipalities and towns. So I was hoping if it was possible for you all to maybe zoom out a little bit and more in layman's terms, kind of say, I guess, summarize what steps municipalities should be taking. I think you mentioned it should be adjudicated first. Could you maybe explain what you mean by that? And maybe expound upon what you said about starting with race neutral remedies versus race specific remedies?
So I can answer. I mean, adjudication wise, what you'd need is a good plaintiff. So you need to have somebody who's willing to challenge a state or city practice based on it being discriminatory and get that court decision. So you need to find folks who at organizations that be willing to fund litigation. Of course, if you win these civil rights cases, they are fee generating, so that's good news. Whatever organizations those might be, and get good plaintiffs to challenge whatever those particular city or state practices are that are discriminatory. And then you would run it through court, you get the adjudication, and then potential remedies. Once you've identified the discrimination, you can have a race-specific remedy depending on the nature of the discrimination that's found. The other thing I was talking about was if you have a city that really wants to take on these issues and wants to be proactive as opposed to waiting till they get sued, then they'd have to create that strong basis in evidence, which means they really would have to do their own fact finding about their own practices and how they are how they are discriminatory, sort of make out a prima facie case of discrimination against themselves. And once they identify the groups that are being discriminated against, in this case, we're talking about African descendants, they would have to try to think about what would be race neutral that would get at that discrimination and maybe try some of those before they went ahead and implemented something. Because I do think the courts are really looking for you trying something else before you make it race specific for the groups that have been discriminated against. And it's got to be specific to those groups. So for African descendants, you got to show that it's actually African descendants that are being discriminated against. You can't just do, we're going for a more diverse group, all minority groups. It's got to be very specific to the particular group that you're trying to help. And of course, in this case, it would be African descendants. And I'm sure they have it. You have to have a city or municipality or state that's willing to make out a sort of prima facie case against themselves in order to set up some sort of reparations. So does that help, Dominique?
1000%. Thank you.
No problem.
I was just going to add that I put it in the chat an example of a great plaintiff would be the family in the Bruce's Beach case in California.
Mm,
I think that that's one of the best examples, but that requires, for example, records that might not be available in, oh, I don't know, a place like Forsyth County, Georgia.
mhm.
Right. So after the 12 purge in Forsyth County, where a bunch of folks lost their land because they were driven out of the county and then it was basically adversely possessed by the white majority that stayed in the county. Like, I'm not certain that that anyone who could trace their lineage to being a family of property owners in Forsyth County, even with all we know that happened in Forsyth County, would necessarily be successful. I don't know whether that's because I'm feeling a particular way about Georgia, right? Or if I am back to being more pessimistic.
Mhm.
But yeah, I think the Bruce's Beach case might be something to take advantage of. Yeah, but yeah, beyond that, I would be concerned that if, for example, let's say you had, let's say it's not California, you have a state or local government that is interested in seriously looking at reparations. My fear is that you're just going to end up getting caught up in the loop that then puts reparations on under a microscope and uses the rhetoric of reverse discrimination and however many generations ago it was, and the fact that it is at this moment negatively impacting the rights of individuals who can take advantage of the narrative of innocence, right? Like, it's not our fault. Like, me living in 2024, I haven't done this, so why should I be held to account for it? And because our national conversation is not one that deals with notions of privilege very well. Hence, we're still requiring people to find an identifiable individual who discriminated against another identifiable individual or group of individuals. So it ends up being a very individualistic kind of analysis in a constitution that seems largely incapable of dealing with collective injury or collective remediation. So it's almost as if you'd have to have facts almost for every single individual who is part of the group, and not, it's a rare person who has, I guess, with the Great Migration, the fact that people and families don't pass on particularly traumatic stories, right? You end up with people who can't generate the evidence necessary because they don't have the documents, or they don't have the stories, or they can't identify a specific person in their family tree who in fact was discriminated against by an identifiable individual who should then be held to account for their discriminatory conduct.
Doesn't that argue, though, for looking at state actions that were discriminatory so that you don't have to get at, it's sort of like that whole issue around the Browns who, were the ship owners or that brought enslaved Africans here. You don't have to get at individual responsibility when you have the responsibility of the state or the municipality that had either had a law or a practice policy of discriminating against, in this instance, Black people of African descent. So, and
Yeah.
that's where I think that's what happened in Evanston. They looked at the housing that the city discriminated against. And I think that would be one way of addressing that and not trying to get caught up in the individual. I mean, even Brooks Beach or whatever the name in California, that was a city policy. It wasn't individuals, it was the city. So
Right. But on the other side, right, on the plaintiff side, those folks had sufficient documentation
right
able to establish
that they owned that
land.
was their family's
Exactly.
property. Exactly. And I understand, I'm not disagreeing with that, but I'm just saying the whole issue of the individualization for the defendant. The other question I have that flows from this discussion and thank you, Dominique, for your questions, is what if a locality or state had discriminated as proof, are willing to say, look, we did not allow Black folks to cross over the bridge. I mean, whatever. But we stopped that practice 10 years ago, and now they can. What impact does that have on attempting to get, if the state, I don't think that the question becomes if the state or locality is willing to say, yeah, this was our track record. Yes, we stopped it in 2015. Yes, we know that the impact of that track record still lingers. So you got a whole package. You've got what I think more Professor Beiner was talking about. And as we got that, they agree, they have the documentation, What happens then? What happens then if it's challenged? Because let's make the assumption that some loving soul is gonna want to challenge their locality for agreeing to a reparative package for something that hasn't been done in 9 years. Why don't we start with Professor Crooms and then go to Professor Beiner?
Ooh, I was hoping you were going to go the other way.
Well, okay. I can switch.
I'll take it if you want me to.
About that one.
Okay, so I think you're in trouble. So I think the more it's happening now, the more likely you're going to be able to actually set up a system to repair it. This is again we go back to the parents involved case where they said, yeah, was it Louisville? Louisville used to be discriminatory and it used to segregate based on race, and now it doesn't anymore. So they can't do anything to actually do a race-based thing, race-based initiative. So the farther you are away from actual active discrimination, the less likely they're going to uphold your race-based efforts, in a race-based solution, in my estimation. Now, again, if you can really show that, this continues to have really, I think you can try. If it continues to have a serious impact on the people who were discriminated against in some way, it would depend on the fact pattern. So it would depend on, what you were trying to challenge on the part of the city, because it can significant consequences for a fairly long period of time. But I think the farther you get away from it, from their actual discriminatory practices, the more difficult it is for them to be able to say, we are repairing that. And you also, they're not going to believe them because they just say it, okay? Mm-hmm. They're also going to have evidence that they actually were engaging in those discriminatory practices. The courts see that evidentiary basis. It's not enough to say, oh, my bad, no, you have to show us that you really were bad to say. So it's a tight window that they're giving for this kind of race-based solution. But you know, as I'm still a little hopeful until they tell me that you can't do it. I think you should keep it in your arsenal of possibilities. So did I help, Audra?
Yeah, and I guess what I'm hearing is, if we discriminated in, let's just use housing, we participated in redlining and, blah, 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 as a locality. And we did it 20 years ago. Got a strong factual case for that. What
Right.
I'm hearing, correct me if I'm wrong, is if for the continuing harm, there also has to be an evidentiary base.
Yes.
Okay.
Yes.
Okay.
And thank you for taking the lead on that one. I agree wholeheartedly, and to throw a wrench into potentially all of this is I also think it depends on what the city administration looks like now. If the city has, let's say, a Black mayor or majority or even a plurality Black city council, I think that that is likely to be used as evidence of the lack of a need for remediation. It's sort of like, because the Voting Rights Act worked, right? That demonstrates that you no longer are harmed in a particular way. And I'm thinking of places like Mississippi, right? Thanks to the Voting Rights Act, I think Mississippi still holds this distinction. It has the largest number of Black elected officials in the country. Now, most people would not conclude that because Mississippi holds that distinction, somehow Mississippi does not continue to operate in a racist way, right? Or that there isn't even an incredibly documented, richly documented history of racial discrimination, terror, and violence in Mississippi. But I could see, if this ended up in front of the court that currently exists, at least perhaps 5 of them saying what you're describing is accurate for that time. But given what we're looking at now, you can't possibly have, let's say, a Black mayor and a Black city council saying that remediation is necessary because the city government as a state actor has acted in a particular way. I think that muddies things up. And for those who are more inclined to kind of a more reductionist kind of analysis, right? They're going to take Black elected officials as being the counter evidence, right? That's going to counter that narrative of this past discrimination, and I was never particularly good at torts, but may in fact interrupt the causal nexus. Right. And then it lends itself to, and all of this is unfolding within the context of a broader narrative about pathological Blackness, individual responsibility for poverty, all of those things. So it ends up being like, well, it can't possibly be because of the state. It's actually because y'all are trifling and can't figure out how to make this work. And we're not responsible for your trifling behavior. We gave you the opportunity and you just failed to take advantage of it.
What about, though, Professor Crooms, if I could even change that narrative a little bit? What about the perspective that if now we have what you pointed out, like a Black mayor, a majority Black city council, that they're actually in collusion with the African community to obtain reparations? Not necessarily that they prove that the evidence isn't true, but that they are in collusion because of, the sameness, so to speak, of the so-called racial identification.
So I think that that then opens those individuals and that administration up to claim discrimination. So then they end up being the ones who are violating the Constitution rather as in their attempt to remediate past constitutional violations, right? So that we focus on, I guess, the more immediate constitutional violation that they would identify, and that would be this Black administration colluding with Black community to get access to resources that they wouldn't otherwise have based on this claim of a need for remediation, when the existence of the Black administration demonstrates that there isn't really a need for remediation.
I have something else, but that I'll see if anybody else. Professor Biner or any of the anybody Therese?
I did want to speak a little bit about, in light of what you're saying, and probably a little bit about what you were talking about privilege earlier. You know, there is this tension that's spoken about in the Students for Fair Admissions case about equality, and dating back to I think he was talking about the Dred Scott decision when he made a quote about equality, and how we should be helping our commissions think about equity, right? Like, we would never say, because there are white people who are in places or positionalities of authority, that therefore there is no, if there's like one, we have like the first openly gay governor in our state. I live in Massachusetts. We don't say, because we have an openly gay governor who's a white woman, that there's no discrimination against gay people in Massachusetts, right? Like, so how do we help people to really think about it, not in terms of equality, but what should we be helping them think about in terms of equity, in order to get to the arguments that we need to be helping them to fashion, to solidify what they need to do in order to make reparations real in their jurisdictions, a real possibility.
Right. I don't know. I mean, I think that the Constitution ends up being a real limitation, because while the Constitution does include the Equal Protection Clause, it is not the Equity Protection Clause. Right. And here, I mean, I know that there are some, let's say, human rights cities that have, I guess, sprung up, been established, right, where the city decides that it's going to follow, let's say, the Race Convention, right, the International Convention on the Elimination of All Forms of Racial Discrimination. That might provide you with an opening, in large part because racial discrimination, as defined in the treaty, is much broader than what it is that the Constitution permits. And I don't know that any of those places where they have adopted either all or part of those international human rights norms as part of their municipal law, as it were, I don't know that, one, they've been challenged, and two, if they have, how those cases have sort of played out. But I think it would be definitely worth looking into, and that might be a way to get in the space, shift the conversation outside of the Constitution, but link it to a different set of norms. But they're norms, even though we don't follow them, they're norms that the United States not only played a role in making sure that those norms were reflected in those instruments, but seem willing to apply at least to everybody but us.
Anybody else on this? I have one question. What if in the scenario you put forward, about the majority, you know, the majority of the legislature, the mayor, and all that being Black, and what wouldn't that also then mean that there has to, maybe let me back up. Wouldn't that also suggest that it's really important to do what Professor Biner was saying, develop your evidentiary basis that could counter the fact that there's either collusion, so to speak, which is what I posed, or you all are evidence that, you know, this discrimination can't be going on because look, you know. So if again, compiling a strong evidentiary base to support that the continuing impact, even if the action stopped 10 years ago, there's a continuing effect on in the community that can be shown through evidence, not just us saying it.
My concern would be if you go that route, then you're in Village of Arlington Heights. Right? Then you're actually arguing impact within a constitutional scheme that claims that impact cases are possible, but we haven't necessarily seen one fly based on the representation that they're still possible. Right? So I don't know if the Constitution as it is set up can in fact accommodate any claim based on the idea of impact, continuing or otherwise.
Professor Biner?
So I would say in terms of just disparate impact, so I would say with a neutral policy, I agree with Professor Crooms. But if you had clearly a clear evidentiary basis that it wasn't based on just some neutral thing, it was really like we're trying to keep Black folks out of this, and the impact of those discriminatory decisions was still happening. I think you have a decent case. You know, I was listening to, I agree that there would definitely be some argument if you had, for example, a Black mayor, which we have here in Little Rock. We do not have a majority Black board of directors, so that you could say, oh, well, you know, obviously there's no more, you know, you've got representation, there can't be this kind of discrimination. You know, the counter argument to that is, you know, we can finally repair some of the damage that was done because we actually do have adequate representation. You know, up to this point, you know, the political will wasn't on our side because we didn't have representation on these boards. We didn't have representation in politics to actually have some impact. So that would be my counter argument. If I came across the cynical argument, which, you know, you're right, Professor Groom's right, they're going to make that argument. How can it be discrimination when you've got, you know, you've got a majority on this board and you've got a Black mayor? But the counter argument is, well, we finally can address some of the discrimination because we finally do have a majority Black board and a Black mayor. It's been going on for, you know, historically for a very long time in this city based on whether it's housing or municipal contracts, whatever it might be. So I think as long as it's intentional discrimination at the get-go, as long as you can show that you are intentionally discriminating, and that intentional discrimination has continued to have a significant impact on whatever area that you're attacking, you've at least got a chance. So, but I agree with Professor Crooms. Impact alone, that you had some sort of neutral policy that caused an impact, is not going to be enough.
Sorry. Is there any room for the framing that the people who created the Equal Protection Clause were really looking for equity? I know it talks about equal protection, but like, I don't think that was what they were thinking about as they created it. And I've done no research into like looking at the statute itself and the history of it, but just thinking of like your previous conversation, like, is there a way to turn that argument against the people who use it against us?
Yeah. Well, okay. So I think that there's a difference in terms of what those who framed the statutes around the Freedmen's Bureau were trying to get at, and in some cases, the same people who framed the 14th Amendment were attempting to get at. And I think that your equity piece comes in on the Freedmen's Bureau side, which was remedial and reparative from the beginning. But at some point during Reconstruction, before we get to redemption, they abandon the Freedmen's Bureau project, right? And then everything loads onto the equality, 14th Amendment, Reconstruction Amendment side. So I don't know that we get there, right? I do think that there's something to be said for the fact that the Civil Rights Act of 1875 was an act that was drafted by a Congress with, relatively speaking, significant Black representation. So there's something to be said. And if you go back into the congressional globe, I want to say maybe 2 of the Black members of Congress at that point spoke in favor of it. But I mean, it starts off including education as being one of the things that they wanted to include. The education piece gets stripped out, but yeah, I mean, because that Civil Rights of 1875, if you look at it, I mean, it is about equality, and it's equality in a very class-based way, right? Because if you look at public accommodations and amusements, we're talking about like Carnegie Hall, the orchestra at the San Francisco Opera, the ladies' car on a railroad for Mrs. Robinson, right? The stuff that they were looking to be able to access wasn't the stuff that was generally being accessed by those who had been recently emancipated. That there is definitely a class piece, and as you take into consideration the class differences among people of African descent at that particular point in time, there's definitely a group of them who were absolutely interested in equality, because all they are lacking is access that they are denied based on their race, although they come to the table with all of the rest of the accoutrement, right, of being middle to upper middle to even wealthy. So I guess I was responding to the idea that those folks were perhaps interested more in equity. I think the equity came on the Freedman side, not necessarily on the other side.
Okay, anybody else?
I would just add that I think that ship has sailed, unfortunately, on the because I think there's, a lot of, the Supreme Court, killed those laws. I mean, I often wonder what would have happened if the Supreme Court didn't do what it did in the civil rights cases, what our country would look like. Anyway, so I don't know that we can really marshal those originalist arguments at this point in time. So, but unfortunately, so.
Well, if we're marshaling the originalist arguments, then they really originally didn't want equity or equality. In some sense, of the history of this country is one that they were pushed to go to get this far, so to speak, have pretty words on the page, so to speak.
Right.
But they didn't really, the originalists, did not want this period.
Right.
There's a minority that might have, but the majority did not want us Black folk to be viewed anywhere near equal. You know, let's be real honest about it. I mean, this is a whole creation on paper that we and our allies have pushed
Mhm.
and pushed and pushed and gotten as far as we've gotten. And then we've got the Supreme Court in its current construction that's saying, you ain't pushing no more. You know, we're blocking. We're going
Right.
back to the originalists.
Well, but okay, so I agree with you, but I'm sort of thinking of like Eric Foner talks about the second founding.
Mm-hmm.
So I agree with you in terms of the originalists who were there at the Constitutional Convention,
Right.
and the originalists who were involved with the ratification of the Bill of Rights.
Mm-hmm.
I don't know that I necessarily reject the usefulness of looking at originalism when you are limited to 13, 14, and 15, because I think it's a different group of people
Mm-hmm.
engaged in a different project that was designed at some point to deal with some of the more egregious parts of what the originalists did.
Mm-hmm. Mm-hmm.
But I think that in thinking about those who want to make arguments about the importance of originalism, right? This is like Scalia. Scalia is fine with originalism until you get to the Reconstruction Amendments, and then we can't talk about originalism because we don't know how to discern what Congress's intent was.
Mm-hmm.
But I do think that if we keep those separate and focus specifically on that project, that post-bellum project, that I think that there's some stuff there that the originalists would have a difficult time countering. And in many respects, I mean, granted, they eventually, although the civil rights cases are still good law, right? But they eventually get rid of Plessy. I don't know, let's take a page out of Dobbs, right? Let's use, even though we might disagree with it, Dobbs's analysis of why Roe and liberty and privacy could in fact be overturned based on, what did they say? It was like basically what sense in the estimation of the majority that whole liberty to privacy jump made or didn't make. So they went back and said, okay, yes, Roe has been here, and you've got, I don't know, Pierce versus Society of Sisters, Meyer versus Nebraska versus Meyer, Skinner versus Oklahoma, Griswold, Eisenstadt, et cetera, et cetera, et cetera. Much of that analysis in that majority opinion in Dobbs sets up Roe as being so poorly reasoned, judicially created, and not rooted in what liberty could properly be understood to include. In some ways, I think that could open up a critique of the court in those Reconstruction and Redemption era cases to say, for example, the fallacy of separate but equal as being consistent with the Equal Protection Clause, for example, was flawed, right? In the same way that they said that liberty and all the rest of that was flawed when you got to reproductive justice. But it's a thought, right?
I'm not sure I follow that.
Part of what the majority relied on to strike down Roe and Casey was they could find, as far as the majority was concerned, no really good evidence that where the court had gone using liberty and privacy to protect rights around reproduction, they couldn't find any evidence beyond what the court decided was important. Hence, they concluded that it was poorly reasoned. It was poorly, it wasn't sufficiently rooted in constitutional principles. And it's as if they came up with a new standard to determine when precedent should be upheld and when precedent may in fact be subject to be struck down. So I'm just saying there could be a parallel kind of analysis as it relates to the court's early cases interpreting for the 14th Amendment in particular to then basically take what they developed as the standard that they used in Dobbs, and then let's say we take that and we take it backwards, right? And then we look at how they came to the conclusion in both, well, I guess you could start with Slaughterhouse, but maybe not. I think we want to keep Slaughterhouse. Plessy and the civil rights cases to say, even though this has been the law for quite some time, or it stood as the law for quite some time, if we use this new analytical framework, we can undermine the continuing legitimacy of it, even though it's old law.
Isn't that what they did in Brown?
And that's exactly what they said in Dobbs. But the concern is that, I mean, some of us are waiting for the other shoe to drop because that's where they're coming next. Right. To say that Brown was poorly reasoned.
Oh, okay. So they did it. The Brown dissed Plessy, but now they're going to diss Brown.
And they raised some of that in the dicta in Dobbs. That and in the oral argument for Dobbs, in terms of, I think the what are they? When you're nominated, then you are the confirmation hearings, right? When they try to get people to say, is this super precedent? Right? I'm not yet on the Supreme Court side of the hearings. Some of them have in the past been willing to say, no, Brown, we're not going to touch Brown. There are some, I think we should be concerned that they may in fact come for Brown, particularly as Brown got moved from a desegregation case to a diversity case. You know what I'm saying? And by having diversity come into play, I think that weakens the argument constitutionally for Brown, because while equality is, in fact, found in the Constitution, I don't think that there is a similar kind of basis for diversity as being what it is that folks are seeking. And also the fact that we found that desegregation and integration did not mean the same thing as far as the court or the Constitution was concerned.
Anybody else?
I'm gonna just pop in for a moment. I want to go back to Teresa's initial question. I do think we could find, so I think we could find history related to the 14th Amendment that would help our argument here. I mean, that is the Congress that did create the Civil Rights Act of 1875. They thought they had that authority. I always am amazed when it's like the people who are right there thought they had the authority. Why didn't the court think they did? These were the folks. So they're probably, I haven't done a deep dive into the legislative history of the 14th Amendment, much to my chagrin. But I bet you we could find stuff there. I just don't see this court buying it. They're originalists of convenience. It's where it helps them. They use it. And I always love when you have dissenters who are the progressives on the court using originalism to go, yo, you guys aren't really originalists. But it's usually because it's the politics of the case that is really motivating their originalism. So that's my cynicism on this one. So.
Anyone else? Well, I want to wrap up with perhaps a statement and proposal and see how people react to it, not just our professors, but anybody. It seems to me, and I gave an impassioned speech last week to our group about advocacy. And if we are advocates for reparations and funded by the Colonizing Wealth Project to push reparations, to support reparations, this wasn't just, this, what is it, neutral. This is not a neutral funder. And the project is not neutral. It's to say, how can we support the obtaining of reparations by providing the various analyses? So my thought continues to be, that we are advocates so that it's not necessarily how it would, I'm not trying to draft it and, for our handbook at this point, but to get a cogent argument that what we do is advise that if you're going after, and I'm talking now just some legislative stuff, I'm not dealing with the litigation, that you must have a credible evidentiary base for seeking reparative remedies from a locality. And it has to be documented. You just can't say it in your head and say, well, I just remember Uncle Joe down the street. You have to develop evidence, evidentiary base, documents. And then, of course, the better path forward is, and you have a locality to avoid litigation at this point, not that it won't be challenged, and you have a locality or state that's willing to say, yeah, we're willing to agree that from X year to X year, we did this discriminatory practice. The second piece would be that we just covered. We stopped it 10 years ago, but there's this evidentiary piece that it has ongoing impact on that population. It seems to me the second piece that needs to be presented, and I'm please everyone feel, I'm saying this to hear the critique back on it, is as that this could be challenged. It could be, and probably is, somebody sitting in that population that is going to be mad. Just mad, right? Not even going to put a color on their face, even though we can see the color, right? Going to be mad. And they may have the resources to challenge it, and we know all you have to do is, file a complaint, pay whatever the filing fee is, and they may then garner more support so they could litigate it. So this could be litigated, right? So it gets to our point that we had with Eric Miller, which you were going to talk some about on Thursday. Eric Miller is an attorney, has done reparations work, but a lot of it on litigation side, is that, if they're going to sue, then they've got to meet, we've got, all the procedural hurdles, standing, statute, all of that, and then have a credible, once they get that, leap into that, and they win that, or they satisfy that, then they have to prove their case. That we're up against a court system, depending on where you are, that has been historically blocking the advances of Black people. Depends on where you are. We know there's some courts, whatever, that have not, that have, but for the most part, let's just say generalized. So that the question becomes for the community, which way forward, not for us, but for them. Now, I throw that out for feedback from anybody, everybody.
I know this isn't what you just said, but it comes to mind, and maybe there are lessons that can be gleaned from the Maryland HBCU litigation, right? Because we were, as Howard, involved in the initial piece of it, and then once it got to a certain point, then a firm took it over, but we were still affiliated with it. And it started with the evidence that Maryland had historically underfunded its state HBCUs. They were able to get the state of Maryland to admit to that. And then the question became, okay, what does the remedy need to look like in 2020, whatever, based on this documented, exactly what Teresa's talking about, right? This documented evidence of intentional race discrimination by a state actor. And thinking, I know that that would only work in places where there are HBCUs, but that could be one way to think about the potential advocacy. And then from there, perhaps through connections between the HBCUs and the communities that look like them and where they often sit, it could go beyond the actual institution to include the municipality in which the HBCU sits. So it wouldn't just be for, let's say, I'm trying to think, I'm out of Maryland. It wouldn't necessarily just be, say, Tennessee. In Nashville, it wouldn't necessarily just be Tennessee State, for example, but it would be Tennessee State, Nashville, the broader municipality, and claims of folks within that community. So it does give you an opportunity to do some organizing so that you've got the town and gown folks coming together and trying to figure out what that looks like, so that it's not just the university that benefits, but that the benefit actually is enjoyed by those members of the communities surrounding those HBCUs, which we know part of that is because of redlining. Part of that was because of residential and other types of segregation within those places that, even though the laws that required the segregation are gone, the patterns of segregation aren't, which is good because that's community, right? Folks were able to create community within the confines in which they had to operate. And we don't want, let's say, a remedy that will then get rid of those communities. You want to be able to, I assume, strengthen those communities as well as the institutions that serve those communities. So maybe there's something in that litigation that could be helpful in terms of thinking about how to move forward with respect to part of it. And I also recognize that I have spent all of my academic career at the poster child for reparations, and that would be Howard University.
Yeah.
We are and continue to be the prime example of what continues to live from the Freedmen's Bureau experiment. And at least right now, we're still with our doors open. Congress, at some point, Colin Powell said during one of those Republican administrations, when they were threatening to snatch our funding, Powell was sort of like, yeah, no, that's not going to work. And I know that I'm a Republican, but this is a bipartisan issue for Black people. Right. And even with Thomas, I mean, I hate to bring him up. The one place where the one place where we tend to agree is his understanding of the institutional and cultural significance of HBCUs. I mean, maybe you're able to peel him off if it ends up going in that direction.
Well, my view is, I wonder if we want to go beyond or use what you just said as a basis for doing more than just HBCUs, because every community doesn't have a HBCU, but every community may have some institutional bases for arguing discrimination that has impacted the whole community. So I agree. I remember this case. And I remember, I think Morgan State got a whole bunch of stuff, and others too, but I remember that, and it's not been so far in the past. So I think that your analysis, I think, is good. And I remember some of it. I was not involved like you were, but I think that can be the kernel of saying it can be done using this model, but it can be done for other institutional type things. It can, even as maybe, it's not ambiguous, even like with Evanston, the funding of housing, or so that, yes, I think that's a fantastic example. No, I don't. I mean, for me, recommending it as the way to go in communities that have no HBCU, I think it could be a suggestion in a community that has HBCUs, but in a community that doesn't, I'm kind of pulling from what Teresa said and some of what you said, pulling, and saying, but you've got to have a strong evidentiary base. 1, 2, if it's a lapse, it's got to be a strong evidentiary base for continuing injury. And 3, you're going to face probably a challenge. So you got to be willing to, do what you can. And if you face a challenge, you got to decide, can you meet that challenge? And it doesn't have to be, you can do A and B and then decide C, we can't meet the challenge because we don't have the money, we don't have not that you can't meet it evidentiary, but you can't meet it because of, the usual questions that arise in litigation. So that would be my response to you.
I mean, I'm the proponent of this approach in the first place, so making the evidentiary basis for it. So I think we need to see some municipalities try it, because right now it is still valid law, and I think if they're going to undo this line of reasoning, we got to make them do it and own it. Because right now, I think there is a basis. They haven't overturned any of these cases. I mean, I know that Croson was a long time ago, but they keep on citing back to that line of authority when they talk about, well, you can remedy discrimination. Okay. And so I think it's worth a try for a municipality that has the resources to do it and has the political will to do it. And let's see how it goes. Keep my fingers crossed. I would imagine if you've got that firm evidentiary basis, it's pretty hard to say that they can't do something about it. I mean, without them saying, "Oh, you can't remedy race discrimination when you find it." I mean, I can't imagine that they'd ever go and say that. I mean, Teresa's she just made a funny face. I mean, they at least, when you find discrimination, you're allowed to remedy it. So they may quibble with your evidentiary basis, right? And find, you don't have the evidence for it. Or, the reparations you've decided to do don't meet the discrimination that you found. they may quibble with that, but I can't imagine they're not going to say you can't remedy discrimination where you find it.
Mhm.
So it's again, making sure you have that evidence and whatever reparations you set up really meets what you found that is discriminatory.
Mhm. Mhm.
So I'm not saying it out loud, Professor Crooms, but it's kind of like the congruence and proportionality test that we use for the Section 5. I mean, that's really, they haven't done it for, you know, states and municipalities, but that's kind of where it's basically like that in the same, I think is the kind of thing you're going to have to do. So I would go for it, Ajahn.
All right. Well, thank you so much. It's, I have gotten a lot out of it. I don't know about anybody else, but I think,
As have I.
yeah, okay,
Okay, thanks.
good.
My
That was
pleasure.
excellent. Thank you. Thank you so much for that information. It's going to be extremely useful. We're going to use the videos as part of what we're doing for the commissions to give them information. So I think even taking the language and making it easier for people to understand is going to be helpful.
And I'm going to put a plug in. I see you have the Lawyers Committee for Civil Rights and the ACLU. I'm going to make a pitch for my own organization, and that would be the Center for Constitutional
Right, Center for Constitutional Rights.
Rights. We take the cases that nobody else will.
Right.
So yeah, keep us on your radar.
Yep.
I'm going to just put that in the chat so
Yeah,
it's
well,
safe.
you're definitely on my radar. So, anybody else? No?
I just
Well,
wanted to say thank you.
Okay, go
So
on,
sorry.
Sam.
Thank
No,
you
go
so
ahead.
much. I was just trying to soak in everything that you were saying and like all of its relation to specifically what we're doing with the task forces. And I guess the biggest takeaway for me was just that I guess the forces maybe like subconsciously or unknowingly are doing that evidentiary work. Like that is what they're doing at the foreground. And so I think that that is the best basis for us to even be successful in this space, is because that's what they're doing. Like that is their goal. And if we can help them kind of either find that, and I think a lot of the issues seem to deal with like funding, but I think their goal is to not just find one thing like land in Fulton County or something, but like all of the ways in which that entity has affected Black Americans. And I think we can get like reparations for all of that and not just one specific way.
Well, thank you again. Really, really appreciate it. I really appreciate the back and, the differences of opinion, but similarities of opinion and how we can structure it. And I think it's just been very, very helpful, I know, for me as well as all the people that are working in the project. And but thank you so very much and really appreciate it. So
Angela, can I ask you one last question?
sure.
Are you all having this conversation or interfacing at all with the permanent forum on people of African descent at the UN level?
No, we have, we have some people that are part of that permanent forum that are a part of our discussions, and Kichi, who is on our reparations committee, along with Shirley, who has signed on, and Deborah Jackson. We also are in communication with Justin Hansford, who is the U.S. representative, or was. I'm assuming he still is, to the permanent forum. But no, we haven't had those discussions with the permanent forum as such, but with people who are part of that.
Okay, because the sister from Costa Rica just got an honorary degree here.
Oh, really?
She's, I want to say maybe the head of the permanent forum. But she's also engaged at the Inter-American Commission level as well.
Okay.
And that could be another place to think about, at least figuring out how to have the conversation across the Americas for people of African descent in a space that is not as multilaterally focused as the UN.
Okay. If you can just text me or send me her information, email me, whatever, that'll be great. We'll keep that, on our list. Okay, thank you. Anybody
Enjoyed
else
the
before we sign
conversation.
off? Huh?
Enjoyed the conversation. If you guys need anything, please reach out.
Okay, will
you.
do. Oh, you know I will. I'm warning you, I will. Just giving you permission to say no. Okay. Thanks so much. Good
All
night.
right, y'all.
everybody.